Hi guys, hello again. So this is today's second stream. This will be focused on the Antonio Sledge, the Mounk Tounk appeal. So this update is the reply from the state. So Fulton County has replied to the original appeal and the arguments made by both Jim, who everyone seems to know as Happily Angry Lawyer. It's one of his many AKAs. Thank you, Trikisha, for sharing the links here. They're also in the description. And Tiffany Adams, also known as the Fit Lawyer ATL on X and over on YouTube. Great content from both of them. Of course, they're also representing Mounk Tounk. And it's worth saying that on Friday, Jim should be doing a stream with some updates from his perspective. So make sure you follow them. Worth it for any number of reasons, but especially if you're interested in following what's going on with Antonio Sledge. Now, what we're going to be looking at is the state's reply. So, if you aren't familiar with what happened with Mounk Tounk, we're going to get some recitation of the basic facts here, and I'll have to gauge whether I agree with the state's version of events. But in short, Antonio Sledge was indicted. He was part of the YSL indictment. He took a plea back in December of 2022. He testified at the YSL trial that many of us watched for many, many days. And during his testimony, he was disputing the factual acknowledgments. He said, this wasn't what the paper was supposed to say. There were different versions of it. And we got some indication that that was actually correct. Well, state filed a motion to revoke Mounk Tounk's probation. He was given probation as part of his plea deal, so he could be let out that day. He could be out of custody that day that he took the plea. Well, since then, a lot of people have been angered about that series of events. One in particular was Jim. He got so angry he looked for an attorney in Georgia, in the Atlanta area, found Tiffany Adams. They end up deciding to represent Antonio Sledge. They first filed a motion to vacate void sentence, which Whitaker granted in part, but she kind of just said, okay, well, we're going to vacate this part of the sentence for one of the counts, but we're just going to move that time to this count over here, this remaining count 1. And it'll be fine. It'll be great. And Whitaker didn't address any of the other arguments that were made in that motion to vacate. So they ended up filing a motion for reconsideration, but Judge Whitaker was like, hey, go to the appeals court first. And once you exhaust that pathway, then come back down to the trial court. So they file an appeal. That was like 30-something pages. It was pretty long. We read that on another stream. It's linked in the description. If you want the nitty-gritty of that argument, I recommend rewatching that stream. But that's the summary for how we get here to the state having to reply. It is worth noting that the prosecutor handling this reply is Alex Burnick, right? So from my awareness, the first time I've seen that name associated with the YSL case, and certainly with anything surrounding Mounk Tounk. So I haven't seen his name before in relation to anything YSL. So that's who we're going to be reading this argument from. Let's get into it. I am ready. Oh, we got Fatima here. Good to see you. I miss you. Yeah, Ash says I'll never forgive Paige for this. I got annoyed. She strikes me as someone that likes to read, and I was very surprised that she didn't address the other arguments in the motion to vacate. She seems like a bookworm to me. Ignored all the other arguments, though, and said, whoop, we're just going to move the time over here. So that was really disappointing. Hey to Jasmine. Hey to everyone also that's coming over from this morning's stream. We talked about the Courtney Clenny case getting delayed again. So probably not a December 1st trial date, and today's hearing was moved till November 5th, maybe the 4th, still unsure. And then the New York State Department of Corrections trial, the 3 corrections officers charged with the killing of Robert Brooks, an inmate. Closing arguments just finished up. We will be on verdict watch. If we get an update, we'll talk about it on this stream. Otherwise, this is all about Mounk Tounk. Hey, Joni P, good to see ya. Got a lot of familiar faces. Always good to have a YSL reunion. Always good to see you guys. And then Nem was saying, so Nem, the revocation was for 5 years. Does he need to serve all 5? I think there's like an 85-15 rule in Georgia. So I'm pretty sure it would apply even though it's sentence in relation to a probation revocation, I think the 85-15 would apply if he meets the criteria, if nothing else changes in the meantime. I hope that he's out way sooner. So let's see. And again, this is the state. This is Burnick or whatever his name is. Appellant Antonio Sledge appeals from his motion to vacate his allegedly void sentence on count 30. Why is this a problem? Why is this a problem? Already. He's appealing from his motion to vacate his allegedly void. Even in this stream, if this is your first time hearing about it, I just recited for you. Whitaker granted this motion. She did find it to be a void sentence. Sure, she found another place to go and move the time. But for what it's worth, that motion, she did find that it was a void sentence. But here the state is already starting his allegedly void sentence on count 30, stemming from his guilty plea to counts 1 and 30 of the indictment. This motion was filed after his probation was revoked for failing to abide by the special conditions of his probation. The trial court granted his motion and voided his guilty plea on count 30, but did not disturb the sentence on count 1. This isn't true. This isn't true. This isn't the mechanism. Guys, we're not even a paragraph in and I'm already annoyed. The trial court granted his motion and voided his guilty plea on count 30, but did not disturb the sentence on count 1. The sentence was moved into count 1. Do we need to pull up this order? Do I even have this handy? I'm already going to lose my mind. But you guys remember, right? You guys remember, Paige just moved, it's been our joke. Paige just moved the sentencing from count 30 to count 1. You guys already know. Oh my goodness. In its order, the trial court resentenced the appellant on count 30 without a hearing. This is true. There was no hearing. Dissatisfied that he remained under sentence and is still incarcerated for his probation being revoked, he now attacks his whole sentence despite receiving the relief he sought due to a defect in one count. Yeah, why did we attack the whole sentence? Because it's a package deal. And not for nothing, but that was argued. This is part of the argument that Judge Whitaker ignored in her order. So this guy writing this has no idea what played out up to this point. He attacked the whole sentence in the very first motion to vacate. So this is such an improper characterization. Guys, I'm not even past the intro paragraph. He did attack the whole thing, and the state's trying to say, well, no, he wants to attack. He always attacked the whole thing. Oh my gosh. And this is why I'm annoyed that Whitaker did not address those arguments. She just said, whoop-de-doo. Even though appellant was resentenced without a hearing, this resentencing did not increase his sentence. Actually, it did, because the math was wrong on the time served. So it did. He entered his guilty plea knowingly, and I need a button that just keeps me going. He entered his guilty plea knowingly and intelligently, as found by the trial court, and confirmed by him in later pleadings. How do you knowingly and intelligently enter a guilty plea that ultimately a court decides by as a matter of law is void? How do you knowingly and intelligently agree to something that by law is void? Despite the trial court informing the parties that the original plea agreement would not achieve his goal of being, so this is going back to Glanville's court back in 2022. So the trial court informs the parties that the original plea agreement would not achieve his goal of being released that day. The parties quickly presented another, which was accepted. And that was not the copy. We have the 1AS exhibit. We don't have the copy of what this was. Further, any other defects from his plea to count 30 would not affect his guilty plea on count 1 due to these counts being considered not as a package but separately. And again, guys, we're not going to, this to me is so ridiculous because this whole maneuvering to figure out something that works is because the package together had to work. And this was argued extensively in the appeal. So watch that stream. It's linked in the description. The document should also be in the description of that video if you just want to read the filing from Jim and Tiffany. If it wasn't a package deal, this wouldn't have been necessary. Further, any other defects from his plea to count 30 would not affect... Oh, wait, I read this one already. Finally, appellant has failed to timely raise his contentions regarding his probation revocation and any ineffective assistance of counsel. Even if his probation revocation claims have not been waived, appellant was given special conditions of probation. Was he? Was he? And the trial court properly took judicial notice of his prior testimony when it revoked his probation. And I don't know if Whitaker's judicial notice was essentially, well, I heard the testimony. No chance for anyone to say if they agree or object. I'm not sure if that's proper judicial notice, but okay. That's when Whitaker was like, and I find it to be akin to perjury. Statement of jurisdiction. So appellant appeals, so they're going to argue this isn't the right venue. The time is exhausted. Appellant appeals from the order granting his motion to vacate void sentence. Generally, denials for motions to vacate void sentence are directly appealable. And they're citing here Ward v. State. But if you see Hood v. State, a motion to vacate a void sentence is in general directly appealable. Appellant does complain that the relief in from that order is insufficient. And void. The resentencing is void. The argument is just not that it's insufficient, it's that it's void. Further, as a motion to vacate a void sentence is an order that is directly appealable, all judgments, rulings, or orders rendered in the case prior to this judgment which may affect the proceedings below can be reviewed. This court, rather than the Supreme Court of Georgia, has jurisdiction over this case as it involves a non-capital felony and does not involve an issue that invokes the exclusive jurisdiction of the Supreme Court of Georgia. The order granting the motion to vacate was entered on April 28, 2025. Appellant filed a timely notice of appeal on May 28, 2025. So what's the issue? I mean, maybe they'll argue it later what the issue is there. But they were acting like it was untimely, and then they're like, it's timely. So, I don't know. I don't know, guys. I'm not a lawyer, so maybe this is just something that I'm missing. Statement of the case. Statement of the case. The indictment. Let's talk about the indictment. Which one? Originally, appellant was indicted in this case on one count. On count 1, RICO, and count 30. 16-11-131. This is the root of the issue. Possession of a firearm by a convicted felon. An indictment ending in 73. We have a footnote. A copy of this indictment is attached to appellant's pleading in the lower court. In this original indictment, count 30's substantive portion alleged appellant did knowingly and without lawful authority possess a firearm, to wit, a handgun, after having been convicted of a felony in indictment ending in 9-4. In the Superior Court of Fulton County, Georgia, for the offenses of participation in criminal street gang activity, aggravated assault with a deadly weapon, and aggravated battery on the 10th day of January 2018. This case was re-indicted. We know about the second YSL indictment on August 5th, 2022, under the current indictment, which ends in 7-2. Appellant was indicted for the same 2 counts, but count 30 alleged 133. Possession of a firearm by a convicted felon previously, who was convicted... Are we just adding words here? Possession of a firearm by a convicted felon previously who was convicted of felony involving the use or possession of a firearm. Why can't we get this right when we're about to argue that this is correct? We still can't just get it right. Just copy and paste the statute. Oh my God. The substance, they're not like missing the elements, but it's just weird grammar. They're like switching up the words. It's like they were copying and pasting, realized they probably put 131 here and said, oh wait, let's switch it. And then copy and paste it in the wrong place. So the substance of the count alleged that did knowingly and without lawful authority possess a firearm, to wit, a handgun, after having been convicted of a felony in indictment ending in 9-4 in the Superior Court of Fulton County, Georgia, for the offenses of possession of a firearm during commission of a felony and aggravated assault with a deadly weapon on the 10th day of January 2018. While the body of the indictment changed the substance of the allegations, the caption of count 30 still alleged possession of a firearm by convicted felon at 131. On December 27th, 2022. So this is after, like, we heard, especially from Tick, from Slug, YSL Slug, Trontavia Stevens, when these guys got arrested, they were looking for bond. They were looking to get out. Denied, denied, denied. You're too dangerous. We're not even going to offer you a bond. But suddenly, at the end of December of 2022, right before trial was supposed to start, jury selection would take 10 months, but they were supposed to go to trial. All of a sudden, all these plea deals rained down. So on December 27th, all of a sudden, Christmas gift. The state and appellant entered into a plea agreement that resolved both of appellant's charges. The plea agreement showed that appellant was currently charged under 16-1-11-133 on count 30. For count 1, RICO, the proposed sentence was 15 years on probation. For count 30, the agreement proposed that sentencing be withheld until after trial due to the special conditions of probation. So I don't get how this isn't intertwined if we're going to withhold, but okay. If appellant completed the special conditions, he would be allowed to withdraw his guilty plea, and the state would enter a null pros on count 30. And we've just got to go back up. This. Let's make sure. We were on page 6. What did we see in the intro? Further, any other defects from his plea to count 30 would not affect his guilty plea on count 1 due to these counts being considered not as a package but separately. How do you reconcile that with this being the structure of it? That for count 30, the agreement proposed sentencing be withheld, and that's the line that Love cut out when she was reciting this plea. She replayed the video in the YSL trial. This was the very specific line that she skipped. The sentencing withheld is what she skipped and then uploaded and then started without playing it. If appellant completed the special conditions, he would be allowed to withdraw his guilty plea, and the state would enter a null pros on count 30. How are they not intertwined? How are they not intertwined? This, to me, seems like an argument that it is a package deal, despite what the introduction says. The agreement listed the special conditions of probation that included testifying truthfully in all matters relating to this case and acknowledging the, quote, defendant's factual acknowledgments that were listed separately. Yeah, tell us how they were listed separately. Appellant and his counsel signed this plea agreement on December 28th, 2022, acknowledging that he reviewed it and agreed to the terms and the accuracy of the statements in the factual acknowledgments. And the only person with a copy of this at this hearing, the paper, was Adrian Love. Shout out to Jim in the building. I think everybody misses you, myself included. So I'm glad you're streaming on Friday, guys. Be there or be square, you know. At the guilty plea hearing, the trial court swore in appellant and reviewed the procedure for the hearing, which was to go over voluntariness and then the factual basis. The state asked the questions during the plea colloquy. The transcript shows the following exchange. So this is Love. Do you understand that you are charged with the following offenses? Yes, ma'am. Conspiracy to violate the Racketeer Influence and Corrupt Organizations Act? Yes, ma'am. As well as possession of a firearm by a convicted felon? Yes, ma'am. As listed in count 30 of this indictment? I mean, this sounds like 131. This is not 133. As listed in count 30 of this indictment? Yes, ma'am. Later. The state advised appellant of the maximum and minimum sentences, which include asking, do you understand that the sentence for violation of count 30 of this indictment, possession of a firearm by a convicted felon, as in OCGA 16-11-133, is 15 years in prison? Appellant affirmed that he understood. Is this where they're going to end on this? Let's see what they say. The plea colloquy also included a review of the rights that appellant was giving up by pleading guilty. Appellant acknowledged that he signed the plea agreement. The state reviewed the written plea agreement in its colloquy, including listing the charges with count 30 as OCGA 16-11-133, the proposed sentences, the special conditions of probation, and the factual acknowledgments. What they're not saying here is that I don't think that they fully fleshed this out, but this certainly took place before the court administrator told Judge Glanville, like, hey, you can't do it this way. And then the court tells the parties, hey, I get that you want to get him out today, but you just can't do it this way. So you got to figure out another option. So to me, this is irrelevant because there's another agreement. There should be another piece of paper that lists everything out. And we just don't have that. When the state asked how he pleaded to count 30, it specifically acknowledged that it was possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm. And we're making Adrian love the it for the state. After the state presented the factual basis, the trial court brought up the issue that pursuant to the negotiated agreement, appellant would have no sentence on count 30 and could not be released unless there was a bond, as informed by the clerk's office. So this is where we get into this, hey, wait, we got to change everything. So even if all of this, we take this at face value, we change everything afterwards immediately. And I don't take this at face value, but okay. Let's see. There was a discussion to ensure the appellant would be released after the guilty plea. The trial court recessed so that the attorneys could discuss. After the recess, the state presented the new plea agreement that appellant be sentenced to 15 years on probation, consecutive on count 30, and that it would not object to a motion to withdraw the guilty plea on count 30. Appellant's counsel told the court that appellant is very anxious to be able to get back to his family. This is Derek Wright, the other attorney. Appellant's counsel asked the court to accept the plea so that he can get back to his family. The state then added that it had no objection to suspending the 15 years on count 30. The trial court then asked appellant if he had enough time to discuss the plea agreement and the case with his attorney. Appellant affirmed he did. Appellant did not have any questions when the trial court asked if he did. The trial court orally sentenced 15 years on probation on count 1 and a consecutive, this is important, consecutive 15 years on probation on count 30, which the trial court referenced under OCGA 16-11-133. The trial court also indicated that with completion of special conditions B, C, D, and F, and I, that appellant could withdraw his guilty plea on count 30. The trial court also reviewed the special conditions with appellant. Neither appellant nor the state had any questions or clarifications to the sentence. The trial court entered the sentence on the final disposition sheet. The written order referred to the charge on count 30 as possession of a firearm by convicted felon, and the statute as OCGA 16-11-131B. The special conditions of probation, including the acknowledgement that the state would agree to null pros count 30 after appellant completed the conditions, were listed in red print as follows. You shall abide in full by each and all the terms of this negotiated agreement. Your failure to abide by any term of this agreement shall constitute a violation of the agreement. B, you shall testify truthfully about all matters relating to this case, upon which you are questioned, at any trial or judicial proceeding stemming from the facts alleged in this indictment. C, in accordance with testifying truthfully about all matters relating to this case, you acknowledge that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. That wasn't part of this agreement. It wasn't in there. You shall testify truthfully about each statement contained within the defendant's factual acknowledgments that are again not included in this thing, and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. You shall possess no guns unless your right to do so is restored. You shall commit no criminal acts. So here we're writing without the double negatives. You shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case. Should you test positive for any Schedule 1, 2, or 3 drug, you shall within 30 days of the said positive test undergo drug rehabilitation as designated by the court or the Department of Community Supervision, and shall successfully complete said rehab program. You relinquish any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement. And then we're going to get into the probation revocation, but let's, give me a second because I want to pull that up just so we see the visual. Let me find the drive. And I want to make sure I get the right one, the right file. Sorry, I have a lot of... Disposition brings up a lot of results. Or actually, I think it was attached as an exhibit. So let me just pull up the original brief that Jim and Tiffany filed. That'd be the smart solution here. Nope, my file doesn't have the exhibit. Dang. I'm 0 for 0 right now. Ooh, maybe in the motion to vacate the void sentence. The final disposition. I want to look at some giant red text. Okay, wait. I think I have it here. Let me open this in a better window than Google's preview. So, going to the exhibits from the motion to vacate. This is the long transcript. Wait, I think you had an outline in this. Super helpful. I don't know what exhibit it was, but we'll find it. This is the indictment. Okay, here we go. Here we go, chat. And look at Aaron, Speed Demon Aaron. Shout out to Aaron. Also, I don't know why my StreamYard made everything blue with these circle things, but we're just gonna rock with it for this stream. But let's see. So we have this final disposition. Defendant sentenced to a total of 20 years, with the first blank to be served in confinement and remainder to be served on probation, or all to be served on probation. Let's get down to the special conditions of probation. Now we have special conditions of sentence. And actually, I'm assuming this might be only the disposition that Aaron linked. So probably better than sending you guys a 600-page document, Jim. So thank you again to Aaron. And we see all of these different things. I mean, they left out, they didn't include this in their recitation in the motion that we're looking at, right? They skipped that part. So they leave out these additional quote-unquote special conditions. Why? You know, I never noticed this before, Jim. But why do they have a bullet that's included with the same alignment? So special conditions of sentence, colon, all of this alignment's the same, but then they have sub-bullets just for additional special conditions. And then they have another condition after it. How is this supposed to be clear to anybody? How is this supposed to be clearly understood? And yeah, why is it not there? Why is this part not... I don't know. But in any case, let's see if they address the argument of special conditions of probation versus special conditions of sentence. I don't know if they will. State filed its petition to revoke. We're going to the probation revocation now. The state filed its petition. This was written by Adam Abadi to revoke probation on October 9th, 2024. The state alleged that appellant violated special conditions A through D. Notice they don't say special conditions of what? Is it special conditions of sentence or special conditions of probation? Notice they're not specifying. Which were, and these are the four, apparently, that the state alleged. Defendants shall abide in full by each and all of the terms of this negotiated agreement. Defendants' failure to abide by any term of this agreement shall constitute a violation of the agreement. B was defendant shall testify truthfully about all matters relating to this case, upon which he is questioned, at any trial or judicial proceeding stemming from the facts alleged in this indictment. C, in accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. And that was why I pulled it up. That's not here. This agreement, none of that is on the paper. None of that is in this. But okay. And then defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding relating to the facts alleged in this indictment. The state alleged appellant violated this agreement when he testified at trial. Specifically, appellant contradicted and disavowed the statements that he had proffered and swore to be true at his December 28, 2022 guilty plea hearing. At the probation revocation, we've got the Mounk Tounk emojis going. Love to see it. Love to see it. Yeah, and Aaron also points out that Glanville added the not committing crimes and not possessing firearms to multiple special conditions, even though they're included in general conditions. And this is why it's, yeah, so you know what, I was about to roll through this, but let's explain why this is a big issue, in case anyone hasn't heard. You know, Jim and Tiffany covered this in their filings. He's also streamed about it. Aaron's talked about it in the chats. But if you've missed why this is so important, when you have a violation, this is based on statute, so Georgia statute, different sentencing guidelines. And if you have your probation revoked, and now you have to do some time because your probation's revoked. There's a difference if the revocation is based on a violation of a general condition or a violation of a special condition. And if someone alleges you violated a special condition and the court agrees, you're at risk for losing a bigger balance. Whereas a violation of a general condition is capped. I think it's 2 years or the remaining sentence, whichever is lesser, right? So the way Aaron explains it, I hate that so much because a violation of special conditions mean the balance of probation can be revoked. This here in this instance would be, for example, we want to revoke the entire sentence. We want him to do the entire sentence. We want to revoke the entire probation and make him serve time for it, rather than it being capped. So really interesting that we make a general condition suddenly a special condition. And thank you, Aaron. Aaron is a great teacher. At the probation revocation hearing held on October 18th, 2024, guys, that was almost a year ago. We're like 3 days away. The state tendered 3 USB drives that had appellant's testimony that were taken from the live streams of the trial. The trial court took judicial notice of appellant's testimony because the judge was there and witnessed the testimony. Appellant tendered 5 emails sent between defense counsel and the state. Appellant also asked the court to judicial notice of appellant's testimony and his counsel's argument at trial. Okay, so this is crappy writing, but okay. Are they saying Mounk Tounk? First of all, this is bad grammar here. To judicial notice. That wasn't Mounk Tounk that asked them to take judicial notice. Didn't the judge just decide to take judicial notice? I do not remember Derek Wright standing up there and saying, Your Honor, I want you to take judicial notice. Appellant tried to argue that he just disavowed factual acknowledgement 8 of the plea agreement. That part, I do remember with Derek Wright, disputing factual acknowledgement number 8, I think about the McDonald's meetup. There's a footnote here that says factual acknowledgement 8 reads as follows. Defendant personally knows that 1 or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. The trial court responded that appellant disavowed more than factual acknowledgement 8, listed another 7 acknowledgments from his agreement that he failed to recognize. After some argument, the trial court asked the probation officer, and that's it? Okay. So after some argument, the trial court asked the probation officer for appellant's criminal history. And you guys remember what happened here, right? The chat sunk. The chat reacted when we heard sexual battery yelled out on the record, in court, on this live stream. Attributed falsely to Antonio Sledge. You guys remember that. So after some argument, the trial court asked the probation officer for appellant's criminal history. The probation officer, why don't you tell us what happened from the argument? Why are we jumping? The trial court asked the probation officer for appellant's criminal history. The probation officer listed a theft by receiving stolen property case out of DeKalb County, possession of cocaine case out of Fulton County, possession with intent to distribute cocaine from Fulton, and the attempted aggravated sexual battery that was the underlying charge to count 30. So they have the opportunity here. And this was pointed out in the appeal brief, that this is falsely attributed to this Antonio Sledge. It was not, this charge does not belong to Mounk Tounk. And yet they still, they could have written this like, yes, this was said out loud here, parentheses, though this was found to be, truly attributed to a different individual. They just let this rock. They don't care. They don't care. The trial court found a violation of probation, calling the violation akin to perjury, and revoked 5 years of probation and reinstated the balance. The trial court entered its written order the same day as the hearing. The order reflected its oral ruling, by stating that appellant has violated the special conditions of probation as alleged in the petition for revocation and revoking 5 years of probation. So we've seen, they're making an argument here, but they're not addressing the actual argument. They are reciting what Whitaker said. But Jim and Tiffany's argument is, look, by a swath, like an enormous amount of case law in Georgia, you have to be specific. You have to make sure the defendant, the individual, is fully informed of what a general and special condition, or plural, of their probation is going to be. They have to be on notice because, again, it makes a difference between if you violate these terms. If it's general, you'd be capped at whatever time's remaining or the 2-year max at worst, because we're going to go with the lesser. But if it's special, we could revoke the whole thing, which means in some instances you could be at risk of going to jail for 15 years or more, whatever your outstanding sentence is. You have to be specific. That's the argument that Tiffany and Jim made. And they're just simply saying here, well, the judge made a finding that he has violated the special conditions. They say a condition, the court found a violation of probation, that it was akin to perjury, which is what Whitaker said. And then they reflect has violated the special conditions, plural. They should be seeing the way they're responding to this issue is reciting the very facts that Tiffany and Jim have pointed out the issue with. We didn't find a specific violation. The specific violation wasn't properly alleged in the petition. And this plural's got to go because we're saying it was a violation. And then they revoked the 5 years probation. Judge Whitaker revoked the 5 years. Now they want to talk about the motion to vacate and the order. So this is going to be in April of this year when we were talking about the, and I think if there was like a habeas petition on the table, this would go up to the Georgia Supreme Court, or if they want to appeal any decision here. I think Jim had mentioned if this fails, they'd go back to the trial court for a different type of motion, and then they could pursue another avenue from there. Lots of moving parts there. But with the Supreme Court, typically you'd be dealing with something, like a habeas petition, dealing with a life sentence to go directly there at this point. Happily Angry Lawyer, always an appropriate name, says, I should mention there were 8 sentences imposed in December 2022. At least 4 of the 8 were illegal. And again, that goes to the concept of why suddenly are you giving everybody a bunch of pleas? Is it rushed? Is it careless? Is it any means necessary? And they're trying to harp on how Antonio Sledge agreed. His attorney said he just wants to get home to his family. Well, if you're going to weaponize a defendant's will to do anything to get out of Rice Street, run it right back at you. Why are you trying to get all these so bad and dangerous people? They weren't eligible for bond. You wouldn't even try to give them a bond hearing. So horrible. Oh, now we're suddenly, by any means necessary, willing to get you to plea out. When the judge tells us it won't work this way, we'll scuffle to make it work because we need this factual acknowledgement that somebody can tie Young Thug to the killing of Donovan Thomas because we don't have proof otherwise. The tea is still warm. It's not hot, it's still warm. There's the residual temperature coming from this, not really this motion, but the way I'm reacting to it, I think is keeping my tea warm. Yeah, so Mounk is another one. Good to see you, Amy. Good to see. I missed the blue heart since we have the @names back in the YouTube stream. Yeah, so we're going to go Gunna, Mounk, Obama, Sledge are all illegal. I have to say, when we had the viral discourse going on X about the Young Thug, the Rat, the Gunna, I don't know what viral outlet, like Daily Loud or one of them, said something about YSL Obama, but didn't say it was like YSL. And there were people in the comments thinking it meant like Barack Obama, that the former president, was somehow involved. because people just weren't aware that that was a nickname in the trial. It had me rolling. And I think Thugger Daily might have came out and given everyone the context, but that was a funny time. There we go. Thank you, Barbie Duff, for the blue hearts. Also, big thank you to that always shows up when there's something going on with YSL and has certainly been here following everything with Mounk Tounk and making sure, that doesn't go under the rug. 14 months is crazy. Thank you. Says, can't keep rewarding the state's F-ups, free Mounk Tounk. That's right. That's right. That's right. Yeah, all the pleas, no bond. And I hope judges are more aware of that. So, on April 23rd, we're going to this motion to vacate and the order. On April 23rd, 2025, appellant filed his motion to vacate, and we're going to do allegedly again. This is so stupid. Why is it allegedly void when a court has determined it was void? Why? Why do we need to put the word allegedly here? Does the state use allegedly when they talk about the accusations they make about somebody? Like, they sound like a blogger who's scared to get in trouble. He alleged that the 15 years on count 30 was outside the sentencing range for OCGA 16-11-131. He also claimed the plea agreement was a package deal on the sentences for count 1 and 30, and both sentences should be vacated. Finally, he stated that his probation revocation was void because it was based on a void sentence. Appellant reserved the right to withdraw his guilty plea prior to sentencing. So let's see, you guys. Let's see. On April 28th, 2025, the trial court granted the motion to vacate the sentence on count 30. It found that appellant admitted in his motion that he entered a plea to OCGA 16-11-131. What? It found that appellant admitted. So Whitaker, they're arguing that Whitaker granted the motion to vacate on a finding that appellant admitted in the motion. That's not how her order read. Shouldn't this sentence just read something? It found that appellant actually entered a plea to sentencing consistent with 131. Why is this admitted in his motion, something that the court is apparently basing their finding on? Is this just bad writing, or are they serious? Like, I was about to roll through this. I was about to blah, 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 blah. What is this supposed to mean? It then found that his 15-year sentence on probation was outside the available sentencing range of 1 to 5 years. The court vacated the 15-year sentence and resentenced the appellant to 5 years. That's not how this went down. Is this where they're going to stop describing what Whitaker did? What? I feel gaslit. Wasn't only 5 years ever revoked? And then she moved the time. Like, oh, we can't revoke it from this because it was void, so we're just going to plop it over on count 1. But it was only ever 5 years. So what is this? I think I'm overdoing it on this part. I think they're just trying to avoid. I think they're harping on the obvious here to avoid the elephant in the room on this. The trial court also denied his request to vacate the revocation of his probation. The trial court reiterated that it revoked his probation that came from his sentence on count 1, which remained intact. Thus, the vacator of count 30 did not affect the portion of probation being revoked. So, and this was the problem because, again, revoking the probation revocation was initially instated 5 years. trial court ends up responding to this motion to vacate, and they do not address, Whitaker does not address the multiple arguments that were raised by Mounk Tounk, Jim, and Tiffany in the motion to vacate, only address like the legal timeframes of it. And just said, oops, that is outside the timetable if we look at 131 versus 133. And we're only making that finding because the defendant admitted it in his motion, rather than it being a problem with the sentencing instrument and sentencing decision from the former court and the final disposition. This sentence is just so weird to me. This is so stupid. The court didn't find that appellant admitted in his motion he entered a plea to 131. The court found that, hey, if he was charged and sentenced under 131 and then sentenced to 15 years, that's a problem because that's outside the timetable. Anyway. But anyway, they're concluding. This to me, I hope this isn't their only argument. I hope we get more here to see. I'm not saying that their arguments will get better, but they should at least argue this more. Their quick summary of why this isn't a package deal is just, it's not a package deal because we say it's not a package deal. Let's get to this and see if they go further. The guilty argument and statement of authority. We've got the first issue that the guilty plea sentencing scheme was not a package deal. So they're going to address this argument raised by Jim and Tiffany. Appellant claims that his guilty pleas to counts 1 and 30 should be considered a package deal. I mean, you kind of included a transcript above where the predecessor judge was arguing with that, and then the parties, after some discussion, reformulated the package deal, but okay. The state submits that the record demonstrates that these two sentences were considered as separate and distinct, not as a package deal. What the heck? Where? How are you submitting this? You submitted the record. This is the record you submitted up here. How does this? Where is this quote from the court? There was a discussion to ensure the appellant would be released after the guilty plea. After the state presented the factual basis, the trial court brought up the issue that pursuant to the negotiated agreement, appellant would have no sentence on count 30 and could not be released unless there was a bond, as informed by the... They argue that this was a package deal. They quote parts of the record above here that show they had to put the deal back together to get the two parts to work in something that fits what's allowable. I would lose my hair. Jim, Tiffany, one of my favorite things about the fit lawyer, and I think it makes sense why she has her name. She's very active, very into her health. She shares a lot of her story, and, as a criminal defense attorney, it's hard work. You're busy, but she says she commits to making time for herself and making sure she steps away from work. She makes sure she goes on these retreats, these getaways, and holy moly, does dealing with something like this paint the picture of why that's so important to do. Because how can you live in this day in and day out and not feel like you're losing your mind? It's like talking to, like, a wall doesn't do it for this metaphor. It's like something worse than talking to a wall. Oh my God. The state submits that the record demonstrates. It's weird that they're saying the state submits rather than just saying the record demonstrates. It's like they don't want to directly argue that the record demonstrates their argument, what they're saying it demonstrates, because they know that's not what it demonstrates. I really rarely ever see the phrasing of, I submit to you in a motion. We know that it's argument. So why are you double clarifying that this is just an opinion? This is just me submitting to you. But I don't know for sure. Something that the record, I think reasonably, any reasonable person would say doesn't demonstrate this, but okay. Oh, let's see. When the written plea agreement was signed by both parties, the agreement proposed that sentencing on count 30 be withheld until appellant testified at the trial. This was offered so that if appellant completed the terms of his probation, no sentence would be imposed. Yeah. At the guilty plea hearing, appellant acknowledged that he understood the recommended plea offer, which reflected the written agreement. The written agreement. Okay. Let's get into this switch up. When the trial court brought up that the aim for appellant to be released that day could not occur under the terms of the plea agreement, the parties renegotiated a new plea agreement, which changed count 30 to a plea to 15 years probation. The state further added that it would not object to suspending the probated sentence on count 30. In relation to count 1 starting. If count 1 didn't exist, then that would necessarily, if they weren't intertwined, because they're trying to say, well, the specific bullet point for count 30 is that we were going to offer to withhold sentencing so he could get out right now. But he was on probation right then and there because count 1 was in effect. How do you separate the two? How do you separate the two? Between the written plea agreement and the subsequent oral agreement that was accepted by the trial court, the parties never changed the terms of count 1, which was 15 years on probation. That doesn't matter. The issue was count 30 didn't work with count 1, so they had to fix count 30 to make it work with count 1. This argument lacks logic. It's ignoring logic. I think it's aware of the logic and purposely ignoring it. It would honestly be like, so say I'm cooking dinner and I want to make a turkey and I want to make potatoes and I want to make mac and cheese. And I'm like, one person's like, hey, you should cook all those things one together. And I'm like, well, we can't do it that way. It's just not going to work because I don't have room to put the turkey and I'm going to bake the mac and cheese and I don't have room in the oven to do both those things. So we got to do this a different way. I might not change my plans for the turkey, but I might say, look, for the mac and cheese, we can mostly prep it. And while the turkey's resting, we can get it in the oven then for that last 15 minutes to get those bread crumbles nice and crispy on the top. I'm figuring all of that out as a packaged dinner deal. Just because I don't change my timeline for what I'm doing with the turkey doesn't mean I'm not treating all of the things in conjunction with one another. Like, this is just ignoring package, please. Oh my God. Generally, this court has stated the end result. Did I read this part? Okay, wait. I think I read it, but whatever. Between the written plea agreement and the subsequent oral agreement that was accepted by the trial court, the parties never changed the terms of count 1, which was 15 years on probation. So they didn't change the turkey plans. Generally, this court has stated the end result of a negotiated plea agreement is, in essence, a contract between a defendant and the state. As such, in many circumstances, it is appropriate to view the final negotiated plea agreement as a package deal, the terms of which should not be treated in isolation from one another, but rather as a cohesive whole. All right, so are we going to disagree with this? This court has looked at plea agreements as package deals when the defects affect the whole deal. This includes when the harm from ineffective assistance of counsel affected counts with larger sentencing exposure, when a trial court improperly amended a negotiated probation condition, and when a plea agreement to annul a charge in one county prohibited another prosecutor from prosecuting on that same conduct. I mean, at least as far as these motions, I don't know if this is coming into play, even though I think it was an issue with some of what Glanville did. Not even necessarily with Mounk Tounk, but some other cases. Are they going to say this is different? They cite Clue, holding that defendant should be permitted to withdraw his negotiated guilty plea to all counts where sentences imposed for counts with larger exposure were void. Hey, what's the problem here? Do you guys remember that when Mounk Tounk, when Judge Whitaker decided, all right, I'm going to grant this motion to vacate, but the remedy here, what I'm actually going to do is, even though I'm going to get rid of it over here, I'm going to move it over there. It was listed that Tiffany Adams was present in court for Mounk Tounk. That was not true. Mounk Tounk wasn't there. He had a right to be present, but he wasn't there. His counsel wasn't there. So when would he have been permitted to withdraw his guilty plea? So I'm glad the state is citing this, but the guy writing this has no clue how this went down. It's almost like he went and looked at the paper and saw present Tiffany Adams and just assumed. Meanwhile, if someone like Adam Abadi had to actually work on this, maybe he'd be aware that there was no hearing held for this. That this was just a decision from the bench from Judge Whitaker. Anyway, then we get a quote from Kaiser v. State, vacating the sentence in the entirety when a trial court improperly amends a probation condition. Not really relevant here. Unless we're conceding that Judge Whitaker is akin to perjury with somehow amending a probation condition at the probation revocation hearing. And then we have Arnold v. State, barring a prosecution for kidnapping and false imprisonment in Fulton County when the prosecutor in Clayton County agreed to enter a null pros on those charges in exchange for agreeing to plead guilty to other charges. I don't see why that's relevant here. But okay. This court also declined to find that a plea agreement was not a package deal. She made no finding whatsoever. I'm going to get mad at how they worded this. This court has also declined to find that a plea agreement was not a package deal. So they're talking about the appeals court, the Court of Appeals. Court of Appeals court has also declined to find that a plea agreement was not a package deal when a trial court improperly imposed a probation condition, but the parties left probation conditions to the trial court's discretion. That's Halford v. State. Additionally, just because one sentence is void, this does not cause the other legal sentences on other counts to be vacated when the sentences are separate and distinct from each other. I don't know. Jim, correct me if I'm wrong here. Because you did make an argument, and you did make an argument that, you know, with Whitaker, the akin to perjury comment, the way she took judicial notice and didn't give a chance to object, especially to the thumb drive. To me, this is kind of, the state is actually, I think they're doing it without realizing it, but kind of creating an avenue where it could be argued what Whitaker did at the revocation hearing was improperly imposing a probation condition that was not in the petition to revoke. And then here they're saying that this court has declined to find that a plea agreement was not a package deal, meaning they haven't made any rulings. This would be a new thing, a new issue for them to consider. So I don't really think this is against the avenue. It's just pushing the problem to Whitaker rather than the state. And then you also say that's not what Halford says. Looking forward to your reply and your Friday stream, Jim. Additionally, just because one sentence is void, blah, 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 this does not cause other legal sentences and other counts to be vacated when the sentences are separate and distinct from each other. So I'm a little confused. We have 3 pieces of case law, you know. Great. This court, you have found, you know, a vacating of sentence on one count to be an issue, to be problematic in terms of something being a package deal. And they give the 3 different types of examples, and then a 4th one, which might be applicable here in relation to Judge Whitaker during the probation revocation hearing and not the state's behavior. It says the court hasn't said that that wouldn't be a package deal. I think this is an open avenue. Oh, this is hilarious. So Jim says that Halford is about plea agreement versus not a plea agreement, not whether a plea agreement is a package deal versus not a package deal. So technically, the court in that case they declined to find. They didn't do this thing in something that was about something else. So technically true. This is hot garbage. Did this guy have like 5 minutes to write this? Maybe he got this right away. Maybe he got this assignment right away and sat for like, what do they have, like 21 days? Maybe he sat for like 19 days just trying to figure out, like, do I really got to deal with this? And then he's just like, the day of, and he pulls up his word processor. And he's just like, here we go, and just gets it done. I don't know. In Clue, this court noted that it could look at plea agreements not as package deals when a defect concerns a lesser offense that ran concurrently, if the counts pertained to different underlying transactions or events, or if the guilty plea was non-negotiated. The Georgia Supreme Court has expressed no opinion on whether a trial court can resentence on other counts for which the sentences are not void to preserve an overall sentencing structure. They've expressed opinions. Their opinions have given broad discretion. So they've expressed opinions that didn't place constraints on trial courts, for the most part. But that's still a decision. That's still opinions. The court has expressed opinions. I think this guy is just not a clear writer. The court has expressed no opinion on whether a trial court can resentence on other counts for which the sentences are not void to preserve an overall sentencing structure. And that's Parrott v. State, which expressed an opinion. However, it has noted that vacating a sentence on one count does not render guilty pleas on other counts subject to withdrawal as a matter of right. All right, so that's not addressing the right to withdraw a guilty plea on count 30. Got Pope v. State, which vacating only a life without the possibility of parole when improperly imposed is void and not disturbing the remaining sentences. This is actually, I think this is intentionally misleading. Because how are we acknowledging an opinion being made here that's helpful to us, but also saying the Georgia Supreme Court has expressed no opinion. We're going to give you the one opinion that seems to kind of maybe be in our favor, and we're going to ignore all of the opinions that give broad discretion to the trial court for resentencing to maintain overall sentencing structure. It's like they're quoting the wording that I'm familiar with, because Jim and Tiffany have done a great job citing case after case. Like, I know the name Parrott v. State. I know the name Clue. I'm learning all of these different case names because they keep putting the opinions. They keep quoting the opinions in their motions. And here we're just going to say they've expressed no opinion on this thing that's almost verbatim from the opinions. This is crazy. Okay, and Jim says he wrote the notice of appeal in Thug's forfeiture case and filed that like the day before this. Okay, so guys, let's talk about priorities. The number one, they said, we need you to handle these two things. This one's more important. This one deals with the money. So, oh my goodness. Yeah, and he just cited all your cases instead of finding new ones. And then got Halford wrong. Let's see. The negotiated plea agreement as to counts 1 and 30 should not be viewed as a package deal, but as separate and distinct sentences. Well, now this is argument. And if all of this were true, then we don't really need to make this argument. When looking at the negotiations and the agreements, count 30 has consistently been seen as a secondary count. Guys. How can something be secondary if it's not part of something? I run a race. I come in second place. FFS is gunning out ahead of me. He comes in first. For Always, Forever, for Life comes in third. Can we look at this race separately? How is something second to something it's not a part of? The answer that you want is in the question that you state. Like, the problem with your argument is in, like, the literal words of your argument. Secondary to what? When looking at the negotiations and the agreements, Count 30 has consistently been seen as a secondary count, one that had its status as conditional. Conditional on what? Oh my gosh. I love watching the Georgia Supreme Court. I want to watch those, was it 7 of them? I want to watch those 7. You know, whenever we watch Brian Steele argue in front of the Supreme Court and we're like, oh, I love when the justices ask these questions. You can read into the questions they're asking. I would love for them to be faced with this paragraph right here. Because I think we'd have 7 people trying to interject and going, secondary to what? Conditional on what? Like, and it's a scheme, right? They put your argument, they're disagreeing with it being a scheme, but guys, oh my gosh. And I'm not trying to put down the Court of Appeals. I don't know their personalities. I don't know if they even stream their arguments or whatever. Jim, I want to go in person. If you have to go for this, I'll make a trip to see my brother. If you get to argue this orally. I want to see this. Both sides, yeah, there's no there. Both sides understood. We're going to get another one. We can't even make it another sentence. We have secondary, we have conditional, we have contingent. What do these words all mean? What do they all have in common? Both sides understood. Maybe not today, as at the time of this writing, that a sentence on count 30 was contingent on appellant's actions, but count 1 never had this contingency. What? Contingent on appellant's actions? This is the biggest reach. They should have used an AI. They should have used AI. 30 was contingent on appellant's actions. No. The judge told you that the sentencing offered for count 1 and count 30, the plea deal, were not compatible. It wasn't going to work with the desired result. You've got to make it work together. While the ultimate agreement imposed a sentence on count 30, this sentence could still be withdrawn had appellant had an opportunity to withdraw. Had appellant completed his probation conditions. Additionally, so that sentence would not be in effect, the state offered that the trial court suspend the sentence until after appellant's testimony. But that's weird then, because that wasn't the judge's finding. The judge revoked this, and until it was pointed out as an issue in the motion to vacate, we don't have the judge saying which count and which sentence. How do they... While the ultimate agreement imposed a sentence on count 30, this sentence could still be withdrawn had appellant completed his probation conditions. What's weird is Whitaker, I don't know if Whitaker was fully aware of the defendant agreeing to that at the plea hearing in December 2022. Because remember, she took judicial notice. I was here for the testimony. I was here when Love played the plea colloquy in court. But Love skipped that part. So Whitaker's finding, relying on the judicial notice that she's decided to take upon herself, is missing a key element of the sentencing withheld contingency. Additionally, so that sentence would not be in effect, the state offered that the trial court suspend the sentence until after appellant's testimony. Like Halford, the trial court had discretion on how to deal with the sentence on count 30 until appellant testified. Is that what Halford talks about? Okay. In contrast to count 30, The sentence on count 1 never differed and was treated as separate and distinct from count 30. The parties never renegotiated count 1. Because they wanted to maintain count 1. This shows that the sentence on count 30 was severable from count 1. Then why didn't you just drop it? Why didn't you charge it separately? How is it severable from count 1? I don't even understand this argument. If you're offering a plea, I mean, has there ever been a plea, a proper plea, that takes an indictment and everything that someone's facing and just doesn't disposition some of the counts? Like, that seems imagined. That seems like a fantasy land. To think that sentencing is severable. And again, when pointed out that there was an issue, there could be something on the record, something to the effect of, well, since, this is the same indictment, but, we're treating count 30 separately from count 1, this is what we're willing to do with count 30. There is nothing. We've cited the record in this motion, in this reply brief. Nothing that they have cited shows that there's any indication that that's the intent, that to treat this as a separate entity over here in its own bubble. Appellant, as he consistently agreed to count 30 being treated conditionally and separately from count 1. Where? What? Give us the transcript of this. Where does the appellant agree? Notice they have no citation here. Where did appellant consistently agree to count 30 being treated conditionally and separately from count 1? Further, when the trial court voided the sentence on count 30, it did not touch count 1 and specifically clarified that the probation being revoked was from count 1's sentence. Yeah, clarified after the fact. Clarified after the fact. Notice this is referring to the decision to vacate the void sentence. If this were the case from the start, they wouldn't have had to vacate the void sentence. Murray v. State, vacating one void sentence does not allow a defendant to withdraw his guilty plea as to all counts. Count 1 sentence is separate and distinct from count 30. Thus, this court should view appellant's sentence on count 1 and count 30 as separate and distinct and not as a package deal. 2, the trial court did not improperly increase appellant's sentence on count 30. Appellant alleges that the trial court increased his sentence when it amended his disposition by adding the clause, aside from the first 5 years that have previously been revoked on October 18th, 2024. The state submits that this is a flawed reading of the disposition form. Footnote says, should this court find that there was error in resentencing without a hearing, this enumeration would be moot. Are they saying that if the Court of Appeals finds, hey, we're gonna say that it's improper because Mounk Tounk wasn't present, didn't have a chance to be heard for Whitaker's decision to vacate the void sentence and resentence subsequently, that this argument is moot? Did they not want the court to make a finding? On October 18th, 2024, the trial court revoked 5 years of appellant's probation. The order of revocation included that after serving these 5 years, that appellant shall be reinstated on probation under the condition of the original order of probation. Under the conditions of the original order of probation. Additionally, in its order, so she found a violation during the revocation of something of quote unquote being akin to perjury, but then is reinforcing, I forgot about this, during that he should be reinstated under the same conditions of the original order. Then why did we need to add a new condition mid-revocation? Additionally, in its order on the motion to vacate count 30, the trial court specifically noted that the quote revoked 5 years was part of the 15 years probation he was serving on count 1, and that the total sentence was now 20 years. The amended disposition sheet reflected the trial court's amendments. In particular, at the top of the amended disposition sheet was a checkbox indicating that this was resentenced on count 30. What? At the top of the second page, the trial court checked the box that the sentence may be served on probation, but added the clause, aside from the first 5 years that have previously been revoked, on October 18th, 2024. So, isn't this contradictory to the state's argument? If they're saying that Whitaker revoked 5 years from the count 1, but then was resentenced on count 30, all while Mounk Tounk wasn't present. And then we're going back to the same timetable that wasn't allowable had the revocation actually been from count 30 that day. It wouldn't have made sense. So how does this go to this argument? It's almost like this footnote is begging the court to find an issue with Whitaker not allowing to have Mounk Tounk present and ignore everything else. Like, don't even consider these issues. Don't weigh in on it. Throw them a bone so they shut up and say, yeah, Mounk Tounk had the right to be present during his resentencing. But please don't look at these other issues. So we were down here. Generally, a trial court may not increase a sentence once a defendant begins serving that sentence. It should be noted that the trial court's revocation of 5 years was less than the maximum possible revocation of the remaining balance, or even the remaining time on count 1. The original December 2022 final disposition sheet marked that he was to receive credit for time served, while the trial court's probation revocation wording, they're blaming Judge Whitaker. Which is fine, but don't put all the blame there. Don't put all of the blame there. While the trial court's probation revocation wording could have been clearer, it did not change the beginning of the service of the sentence. We have a footnote that says, this court has also stated that the remedy for any improper guidance and instructions to correctional custodians is to remand the case and instruct the trial court to strike the offending language from the order. Yeah, this right here is a plea. Please don't issue an opinion on any of these other arguments. Please just kick it back and say that the judge was wrong for this one thing. Further, the amended disposition sheet only affected count 30 while unchanging count. The start of count 1's term did not alter under the amended sentencing sheet. Count 30 was also unaffected because both sentence sheets reflect it ran consecutively and began after count 1 ended. Thus, there was no increase in sentence. This enumeration error should be denied. I think this was one of the most confusing parts of the argument when we were going through this. I feel like we slowed down when we were reading the initial appeal brief. But I think this whole paragraph is just saying, look at the issue of Mounk Tounk not being present, that there was no hearing for this resentencing, and ignore everything else, rather than actually address, was Whitaker during the revocation hearing looking at count 1 or count 30? It's like we're ignoring that argument. And then during the decision in response to the motion to vacate, how does that reconcile with what happened at the probation revocation hearing? They're not really hashing that part out. And I don't know, personally, I feel I'm the type of person where if I'm getting the vibe that you don't want me to look at this, now I want to look. So I would go back and I would look at the appellant's argument, Mounk Tounk's argument, and I'd really have them break it down. I'd have them break down the record for me. And then I'd go and look wherever I need to math the math myself. But this right here is like, if you try to accept this at face value, there's parts missing. So, yeah, and then Hal says, we argue that the sentence was increased on count 1. They argue it wasn't increased on count 30. And like, to me, that's the heart of the issue. Because they're also trying to argue that they've got this non-package deal. It's not a package deal. But they're also trying super hard to say it only touched count 1. Count 30 was so separate. Count 30 wasn't impacted. But then if we're arguing so strongly that count 1 was increased and go with your argument on it, we have a separate issue because now you're erasing the start time because count 30 was withheld. Sentencing was withheld for count 30. Count 1 was, the clock was running. The service of time for count 1 was running when the first final disposition was entered in December of 2022. So if they're not addressing, if they're just going to say, well, it wasn't increased on count 30, then it was necessarily increased on count 1, and now we have a time served counter clock problem. It's kind of like a catch-22, and it's complicated for me to try to understand and parse out, but I don't feel like they're addressing it. I don't feel like they're addressing. On one hand, they're going, this is fine because of this, and then ignoring why that opens another rabbit hole over on this side. Oh my goodness. Guys, we have another counter. We're going to see why they disagree. Oh. They're going to argue with Jim and Tiffany for argument 3. Argument 3 is the trial court likely improperly resentenced appellant without a hearing. We're going to get the concession. We're going to get the Whitaker under the bus. I'm excited for this part. I am excited. I am ready. Also, big shout out. I see Fallon May in the chat. Welcome to a YSL reunion here. Thank you for the 10. Says, hey, Kat, thanks for keeping us updated. I'm really excited to see this. I didn't expect it to be this much of a dumpster fire. But holy moly. Thank you so much. I'm so glad you're here. Hope you're doing well. Oh, the trial court likely improperly resentenced appellant without a hearing. What does this argue? Appellant alleges that he was improperly resentenced without a hearing because the trial court retained discretion to reconstruct the sentence on count 30. I thought they argued that above that the Court of Appeals has no opinion on these things. So where are they deriving this conclusion that the trial court does have broad discretion to reconstruct the sentence on count 30? Again, when there's a package deal, when the sentences are interlinked. Why are they embracing that here when they denied that above? They continue. They say the trial court likely had a right to be present by resentencing him on that count without a hearing. As stated above in section 1, any violation of this right affects the sentencing on count 30, not count 1. These were separate, but part of it was that he could withhold sentencing because of count 1 if he started serving count 1 right away. As stated above in section 1, any violation of this right affects the sentencing on count 30, not count 1. These were separate and distinct sentences. The guilty plea should not be considered a package deal, as the contemplation of a fixed sentence rested only on count 1, not count 30. And so this is the end of this part. But they're not addressing the other issue with this. Sure, he should have been present, but they're acting like if he was present, he only would have had the opportunity to object to not being able to withdraw his plea on count 30. They're not mentioning that his counsel could have raised an issue with these terms of resentencing and made an argument about the package deal issue. They're ignoring that if there was an opportunity to be heard, that more than one thing could have been raised. Whew. That was a nice little short one, though. We're blaming the court in one paragraph, and we don't want her mad at us in case this goes back down to her. The trial court properly found that his guilty plea was intelligently and voluntarily entered. I still don't know how this reconciles if the sentence in relation to the plea, that the plea was based on a negotiated sentence. I'm agreeing to this plea because of negotiations that would give me XYZ sentence, can be intelligently entered if it was void as a matter of law. I just don't see how anyone can argue someone's plea was knowing and voluntary under those circumstances. Appellant alleges that he did not intelligently enter his guilty plea because he did not understand the charge on count 30 to which he was pleading guilty in violation of his due process rights and USCR 33.8. The trial court properly inquired and found that appellant entered a guilty plea to OCGA 16-11-131B. Yeah, but he thought he was at risk of facing a consecutive sentence, not concurrent. So right there, you're admitting, if you want to say he was aware it was 131B, there's a big difference between thinking you're facing 15 years for something that can be served at the same time you're already going to be serving for something else, versus an additional now that would math you up to 35 years max, with a much higher bar for the minimum time. An appellant's subsequent pleadings show that he understood this count. How, when you have different counsel? This is the stupidest argument. This is the second time they're hinging on a pleading from this appeal with new counsel that suddenly this is really arguing that because we made a motion saying something was null and void as a matter of law, that appellant knowing and voluntarily entered this plea agreement. It doesn't matter if I want to agree to something that's null and void. This is stupid. This is so stupid. I would use my word count like just screaming in response to this accusation that somebody's motion in 2025 shows that they knowingly agreed to a sentence, a negotiated plea in 2022 that has since been vacated and restructured through resentencing. A guilty plea must be knowingly and voluntarily entered. Making a knowing and voluntary plea requires an understanding of the nature of the charge, the rights being waived, and the consequences of the plea. That's McDaniel v. State. And then we have from Cooper v. State, USCR 33.8a provides that the trial court should not accept a guilty plea without first determining that the defendant understands the nature of the charges against him. So are they saying, they're saying that because the court accepted the plea, it's fine. While the requirements of UCSR 33 are mandatory, the court need not specifically address each issue found in UCR 33.8. Whereas here, the defendant has legal representation, a presumption arises that defense counsel routinely explained the nature of the offenses in sufficient detail to give the accused notice of what he's being asked to admit. But again, like, I get that, we have issues with ineffective assistance of counsel, and I'm surprised that they're citing this here when we had a change of counsel. So they're relying on a presumption from this Henderson v. Morgan case that defense counsel routinely explained the nature of the offense in sufficient detail. But the above cited the reference to the record that Whitaker took judicial notice of Attorney Wright and Antonio Sledge disputing what factual acknowledgments and what substance they actually agreed to and were emailing back and forth. So, is this even relevant here if we have a switch of counsel? Who also has argued ineffective assistance of counsel in this appeal. They didn't do it in the motion to vacate, but again, you try to close one door, another door is opening. You try to put one can on the grocery store shelf, another can falls off the other end. The state has the burden of showing that the guilty plea was intelligently and voluntarily entered. Yeah, and a great way to show that is by playing a clip in court during the YSL trial that cuts out the sentencing withheld part. In addition to the record of the guilty plea, the state may satisfy its burden through extrinsic evidence. Appellant's claim that the possession of a firearm charge on count 30 contradicts his pleadings post-guilty plea. What is the claim, though? They didn't finish this sentence. It should say, appellant's claim that appellant's claim that the count 30 contradicts his pleadings post-guilty plea. His claim of what about count 30? What is the claim that he's now making in a pleading that contradicts? This is missing. Even though the plea colloquy and indictment referred to both possession of firearm counts. Appellant in his pleadings post-guilty plea show that he understood that he pleaded guilty to OCGA 16-11-131B in pursuing his motion to vacate count 30. And it doesn't matter, though. It still needs to be explicitly stated. They're trying to use a 2025 brief to justify a void sentence and somebody agreeing to that, what would ultimately result in a void sentence in 2022. There is undeniable evidence that on December 28th, 2022, Mr. Sledge entered a plea to possession of a firearm by a convicted felon as codified in 16-11-131 and not 16-11-133. This isn't... Yeah. This is like, we've heard they raised this earlier in the motion. They're coming back to this argument here to spell it out. Their issue is that appellant's claims, his words, his state of mind, the fact that he understood, they're raising an issue. These filings show that he understood in 2022 that he was pleading guilty to 131. The quote says, there is undeniable evidence that on December 28th, 2022, Mr. Sledge entered a plea to possession of a firearm by convicted felon, 131. This is their citation? Are you serious? Where does it say that Mr. Sledge knowingly entered a plea to possession of a firearm? Because they're arguing here that his pleadings show that he understood that he pleaded guilty to 131B. Meanwhile, the argument is, hey, it's undisputable that what he was actually pleading to was 131. This is so asinine. And I thought it was bad writing, but now they're saying it like 3 times. And this is the quote they're using to back it up. And I was saying, this is like, this type of critical reading, I mean, I feel like a lot of us would catch this because we're used to looking word for word. I get in everyday language conversations, sometimes people don't say things so clearly. But when you're a prosecutor and you're supposed to deal with elements, you're supposed to deal with mens rea, knowingly, voluntarily, state of mind. It's not a mistake to make an argument that appellant admitted in his pleadings that he knew in 2022 that what we really meant was this other charge, even though our indictment said something different. That's not acceptable anyway, but it's also the quote you're submitting here as proof that he knew something isn't proof that he knew something. The argument isn't even alleging that Sledge knew of 131. And how would he know when the state doesn't? The best interpretation of this paragraph is that it is in fact a concession by the state. That, yup, they're agreeing that Antonio Sledge is smarter than the state. I'll allow it. This is crazy. Jim said something else was his favorite part earlier. I want to say this is my favorite part, maybe because it's not actually my favorite, but it's so frustrating. How does this sentence comport with this? We're never going to get through this. Let me keep going. Appellant, shout out to Steph in the building. Oh my God, it's so good to see you. We get this nice little straight face. Oh my goodness. Appellant also stated in this motion, therefore, Mr. Sledge entered his Plea. Did they not copy and paste you? You did not write Plea. I think we called out a few typos, but I do not remember a Plea instead of plea. So they're inserting typos into quotes. Therefore, Mr. Sledge entered his plea. Where's the word knowingly or intelligently? How does this quote, as an also citation, support the state's argument? This is so stupid. Mr. Sledge entered his plea to 131B as listed on his final disposition. The trial court accepted this assertion and found that the original sentence was void due to being outside the sentencing range for 131. This admission in Judicial should be evidence that... Now we're saying it should be. You just argued it was. This admission in Judicial should be evidence that appellant understood that he was pleading guilty to and sentenced for OCGA 16-11-133. Even if Sledge knew this in 2022, which is not at all what any of this suggests, it doesn't matter. The state should get this right. The court should make sure it's right. So they cite Johnson v. State, acknowledging admissions in Judicial could be considered in criminal cases. Considered. Does this apply to... I know this isn't relevant. I bet you this Johnson v. State case that they're citing here is like somebody said, like a fact. Somebody wrote a fact in a pleading. And that was used in some type of other argument at the trial court level or something. Maybe even at the appellate level. But it dealt with a fact at issue. And through a pleading, a party introduced a fact that would go to the actual elements of the crime. I highly doubt that this state is dealing with, hey, if we get the indictment wrong, and then we want to change it up because the sentencing math is at issue, we can just do whatever, and as long as the defendant says yes, they agree. And if they put in a motion arguing later that it was void, the defendant necessarily knew it was void in 2022, just because we say so. I know that's... and what is this? Oh my gosh. 2017 case? I hope the Court of Appeals, they look at this case. There's just no way. And Jim says, yes, it was a literal statement made by the defendant. Not an appeal issue about a void sentence. A legally void sentence filed by new counsel 3 years later. Oh my goodness. Friday's going to be fun, you guys. Happily Angry Lawyer. We're going to call your streams Happy Hour with Happily Angry Lawyer. I can only imagine. Oh my goodness. I don't even know where I was. Something here with State v. Johnson. Okay. And then we have another case. Wanshoff and Erdman says, and applies only to the admission of fact. Why are these citations worded weird? Typically you'd see a notation if there's like SIC, sick, if seek, I don't know. If we're quoting something that is hard to read, but the mistake is part of the actual transcription or the actual paperwork. You'd see an indication there. But it's like they're making these citations and getting something wrong every time they quote something. And applies only to the admission of fact and does not apply where the admission is merely the opinion or conclusion of the pleader as to law or fact. Doesn't this support against their argument? It's not an admission of facts. Here, appellant undisputedly claimed to the trial court that he understood his guilty plea on count 30 to be 16-11-131B. How is he claiming it to the trial court? Anyway, there's a footnote. Footnote says if appellant did not intelligently or knowingly enter his guilty plea, appellant should have filed a motion to withdraw a guilty plea on that basis. Well, guess what? He didn't have the opportunity to do so at sentencing, at resentencing. Are you serious? However, appellant chose to file a motion to vacate count 30, stating he pleaded guilty to OCGA 16-11-131B and should have been sentenced according to that charge. I want the transcript where they read this out and say, do you knowingly and voluntarily agree to 131 as charged at 131B? It doesn't exist because that's not what Mounk Tounk explicitly agreed to at the plea hearing. But secondly, he filed a motion to vacate the sentence. The court agreed, Whitaker agreed, we're disputing the lack of restructuring and the continued sentence, right? That's the issue now. But at that moment, Antonio Sledge should have had the opportunity to withdraw his guilty plea on count 30. But he was denied the right to be present at this resentencing. So let's highlight that in a footnote. Further, the trial court properly found that the guilty plea was intelligently and voluntarily entered. The plea colloquy reviewed his rights and the charges on the guilty plea to which he was entering. Yeah, and that charge didn't... There is no testimony contradicting appellant's answers that he understood the charges to which he was pleading guilty. And we have another footnote. There has been no hearing on this as no motion to withdraw a guilty plea has been filed. He didn't have a chance. And maybe there will be one. Maybe there will be one. Further, the trial court properly found blah, blah, blah. The plea colloquy reviewed his rights and the charges on the guilty plea to which he was entering. There is no testimony contradicting appellant's answers that he understood the charges to which he was pleading guilty. The only extrinsic evidence, which is appellant's admission in later pleadings, shows that he understood the nature of the charges. How many times are we going to harp on this? The state is using Jim and Tiffany's words in a pleading as if they retroactively apply to Mounk Tounk saying, yes, he understands, in December of 2022, even though the quotes that they give us from Jim and Tiffany do not at all suggest that Mr. Sledge knowingly and voluntarily meant to plead to 131 in 2022. Finally, should this court find that appellant did not enter a voluntary or intelligent plea to count 30, I hope they find that. Any error does not extend to count 1. The plea colloquy shows that appellant understood that he was pleading guilty to RICO and was accurately informed of the minimum and maximum sentence for that count. Appellant does not complain of any defects in his understanding to count 1. He treats it as a package deal. Also, as stated above, the court should not consider the guilty pleas to this 2 counts as a package deal. Thus, the enumerated error should be denied. 5, the trial court did not improperly reject appellant's original plea agreement without allowing him to withdraw his guilty plea. Appellant alleges that the trial court improperly did not give him the opportunity to withdraw his guilty plea after rejecting it. Well, now you're trying to use that against him So I'd argue that this is a material issue, but okay. The state submits that appellant was not harmed in not being advised of his right to withdraw the guilty plea. We're seeing that submits. I think they know that this isn't a strong argument to make. After the parties' original plea agreement was presented at the guilty plea hearing, the trial court informed the parties that under those terms, appellant would not be released unless he had a bond, according to the clerk's office. There was a discussion to ensure that appellant would be released after the guilty plea, with different scenarios being hypothesized. Why would you need to work out different scenarios if count 1 was separate from count 30? Wouldn't you just need to figure out what to do with count 30? Including what bond? The prosecutor asked if she could confer with the appellant's counsel about the plea. The trial court responded, "Sure, you have a couple of options. You just can't do it this way." The trial court recessed so that the attorneys could discuss. After a recess, the state presented the new plea agreement that appellant be sentenced on count 30 to 15 years on probation consecutive, and that it would not object to a motion to withdraw the guilty plea on count 30. Appellant's counsel told the court that appellant is very anxious to be able to get back to his family. Appellant's counsel asked the court to accept the plea so that he can get back to his family. The state then added that it had no objection to suspending the 15 years on count 30. And I would argue they keep reiterating this. They agreed to it. But the reason stated for the agreement is pressure to get back to family. It's not, we understand these terms. We think it's a lovely, flowery deal. We love it. We want to accept it. We're doing this knowingly. We're doing this because by any means necessary, whatever, pick an option. I want to go be with my family. My mom is sick. This court adopted the bright line test found in UCR 3310 as to the rejection of guilty pleas. It says that if the trial court intends to reject the plea agreement, the trial court shall on the record inform the defendant personally that 1, the trial court is not bound by any plea agreement, and 2, the trial court intends to reject the plea agreement presently before it. 3, the disposition of the present case may be less favorable to the defendant than that contemplated by the plea agreement, and 4, that the defendant may then withdraw his or her guilty plea as a matter of right. If the plea is not then withdrawn, sentence may be pronounced. Here, there was no rejection by the trial. Are you serious? Kat, are we going to have to break down the words can't versus shouldn't? I was wondering where this went. I'm like, well, the judge Glanville didn't read this, so this would be an issue, right? Well, the state's then going to argue that, well, it's not an issue that the state didn't inform Mounk Tounk of this, because there wasn't a rejection by the trial court, and this is only warranted if they reject the guilty plea. What did the court do? The court didn't reject it. Just after hearing the original plea agreement, the court informed the parties that the agreement would not achieve the goal that appellant be released from custody that day. It did not reject the plea agreement, but merely informed that the proposed agreement would not achieve their objective. That's why we're relying on, we just want to get out, we just want to get out. Additionally, so how is it knowingly at that point in time if it wasn't going to achieve the one thing that they're saying they wanted? Additionally, the parties request to confer with each other, and they said above that it was Love that asked. They said the prosecutor requested to confer with the other party. But now they request to confer with each other. Preceded the trial court statement, you can't do it this way. Guys, what does can't mean? Did, for the sake of just, we want to make sure you meet your goals. Is that subjective? You just want to make sure we meet your goals. You should do it this way. That's not the same as you can't do it this way. Unequivocally, can't do it this way is a rejection of the structure that was presented to the trial court. It's not, I could accept this, but are you sure? Maybe you guys should confer a little bit more. I don't feel like this is knowingly at this point in time. Go reconsider and come back to me. Talk for a minute. You can't do it this way. You can't do it this way. Can't is a rejection. In what world is the word can't not a no? Guys. But they're arguing that the parties' request to confer with each other, because apparently it was mutual and not initiated by love, preceded the court statement that you can't do it this way. The parties submitted this change as an amendment to the plea agreement. The trial court did not expressly reject this agreement, but suggested that it would not achieve their goal for appellant to be released the same day. You can't do it this way. This ground also fails because the parties came up with the new plea agreement, contrary to Lawrence and Mulkey and Troop v. State, where the trial courts rejected a plea offer and fashioned their own sentence. The trial court here only followed the subsequent plea recommendation that the parties brought before it. The trial court did not alter the agreement sua sponte, but sentenced according to the parties' new proposal. There is no harm here. I mean, they only agreed to a sentence that was legally void. But okay. Unlike cases in which this court has reversed, appellant was involved in the crafting of his new agreement. It came shortly after a recess, and the trial court accepted this new proposed guilty plea agreement. We have a footnote here. It should be noted that appellant was represented by counsel when the new guilty plea agreement was created. But see Lawrence, I don't know why that's italicized, rejecting that counsel informing a defendant that a harsher sentence could occur after a trial court's rejection of a plea agreement could fulfill the trial court's legal requirements. Well, thus, even if the trial court failed to inform appellant that he could withdraw his guilty plea after rejecting it, there was no harm, because he had an attorney. This claim should be denied. This is crazy, guys. Today I learned that can't is subjective and not a no. And not a no. I don't know. Do you think? I would love to hear what logic got you to this conclusion. I don't think it exists, though. So 6, appellant's claims about his probation revocation are untimely, even if this claim can be raised on appeal. The special conditions of probation were clearly stated, and the trial court properly found specific violations. Appellant makes a 3-pronged claim, in that he alleges his disposition sheet does not allege his special conditions of probation, the state failed to allege specific violations of his special conditions, and that the trial court did not find any specific violations of his special conditions of probation. The state submits that these claims are untimely as he did not make a discretionary appeal. If this court determines that these claims are not waived, the trial court substantially complied with OCGA 42-8-34.1 when it listed special conditions of probation under the heading Special Conditions of Sentence. I mean, I guess it was tucked in under there. I don't know if someone substantially, is this supposed to be substantively complied, is enough when the other party here, the appellant, has provided like 4 or 5 different cases that cite other cases, that it needs to be explicit and clear. So when it listed special conditions of probation under the heading Special Conditions of Sentence, so I think this was to be substantively complied, not substantially. But the case law says it needs to be specific, and they're not countering the case law yet. Let's see if they do. First, appellant cannot bring his claims related to his probation revocation on appeal. Quote, appeals from orders revoking probation must follow the discretionary appeal process under OCGA 5-6-35. Appellant has not identified how he can bring claims about his probation revocation months after the time for a discretionary appeal has run. His probation revocation, because this is based on the motion to vacate, his probation revocation was on October 18th, 2024. He had 30 days from October 18th, 2024 to file his petition with this court. He did not do so. He now bootstraps his grounds relating to his probation revocation to a direct appeal from a motion to vacate that was filed about 5 months after his time for a petition on his probation revocation had passed. Well, what's the problem with that? If a sentence is void, the time frame doesn't matter. You don't run out of time for a discretionary appeal when something is void as a matter of law. So that motion was filed. It's a new issue. Whitaker hands down a decision, and now we're arguing things in relation to that decision. So if this could occur, then a party could file any motion regardless of its merits that could be directly appealed and be able to appeal any order regardless of its timeliness. Also, the probation revocation from count 1's probationary period would not affect the proceedings below as to the guilty plea in count 30. The probation revocation does not bear on the issues with count 30's validity. Thus, his claims relating to the probation revocation cannot be brought in this appeal. Even if he could bring his probation revocation claims in the direct appeal of a motion to vacate, his claims fail on their merits. The trial court listed appellant's special conditions of probation. Appellant relies on an overly technical reading of his sentencing sheet in asserting that the trial court did not impose special conditions. I mean, maybe it's a technical reading, but is it an overly technical reading if the case law says it must be explicit and that it must be special conditions of probation? Now we're going to define it. So under OCGA 42-8-34.1, a special condition of probation is a condition that, 1, is expressly imposed as part of the sentence in addition to general conditions of probation and court-ordered fines and fees, and 2, is identified in writing in the sentence as a condition the violation of which authorizes the court to revoke the probation or suspension and require the defendant to serve up to the balance of the sentence in confinement. The Supreme Court has noted, substantial compliance does not require that the language should be exactly as prescribed by the statute, but that all the essential requirements of the form be prescribed. The essential requirements would be the sections, the sections and the material within each section. When there is actual compliance as to all matters of substance, then mere technicalities of form or variations in the mode of expression should not be given the stature of noncompliance. I don't know. I think that'd be pretty interesting if they find that, hey, a special condition of sentence or special conditions of probation are substantively the same. And then they have, let's see, Harvey v. Meadows. It says a substantial compliance with any statutory requirement, especially on the part of public officers, shall be deemed and held sufficient, and no proceeding shall be declared void for want of such compliance, unless expressly so provided by law. Unfortunately for them, I think the case law is really explicit. So I'd like to see them address that. Here, the final disposition form substantially complied with the statutory requirements. Appellant's reliance on the distinction between special conditions of probation and special conditions of sentence is unfounded here. They're coming for you, Jim. Under the section special conditions of probation, the form puts appellant on notice that any violation of the special conditions of probation can result in revocation to serve up their balance of his sentence. Further, the form checks the box that results in the sentence. The defendant shall comply with all special conditions of probation as follows. And then we have the colon. The only information that followed was the negotiated sentence, which was written in red ink. No other conditions followed this sentence. This including section 3, denoting special conditions of sentence, and listed the special conditions as outlined in the negotiated agreement. 2 other conditions were listed underneath, additional special conditions, which were left out above. To construe these conditions as anything other than special conditions of probation would be absurd. There are no special conditions of a sentence, which is why you guys shouldn't be writing things that way. As special conditions only apply to probation. No other conditions are listed under the special conditions of probation other than those that were part of the negotiated agreement and written in red ink. And minus these additional ones that you left out above. You included it here, but you left that out above when you quoted the conditions. No other conditions are listed under the special conditions of probation other than those that were part of the negotiated agreement and written in red ink. And again, as Aaron has emphasized, those special conditions include general conditions. So, with appellant's reading, the trial court's indication that special conditions followed would be meaningless as no conditions would be listed underneath it. To follow appellant's reading, there would be no use to having conditions A, G, and H, as those would have no effect. Also, these conditions were listed within the special conditions of probation section of the sentencing sheet. There is no dividing section that separates these special conditions of sentence from the special conditions of probation section. By its form and context, the special conditions of sentence are clearly the special conditions of probation. Further, appellant acknowledged in his written plea agreement, appellant understands fully that if he violates any provision or any special condition of this plea agreement, his probation for the sentence may be revoked in its entirety. So are they just going to say that everything is now a special condition no matter where it is? Appellant understood that the special conditions of the plea agreement were to be incorporated as special conditions of probation in his sentence. That's not clear because this would also apply to the general conditions section. And now they're arguing here that this applies just to special conditions. While acknowledging that this evidence is outside of the sentencing sheet, it shows that appellant understood these conditions were to be included as special conditions of probation as they were included. Shepherd or Gardner v. State. Let's see. Holding an oral advisement of the special conditions of probation do not fill the written requirements. As cited by appellant, does not apply. So they're saying that Gardner v. State does not apply. Unlike Gardner, here there was different section delineating the special conditions of probation with the conditions listed below it. There was no special conditions of probation section or language in Gardner. The trial court substantially complied when it listed the special conditions of probation under special conditions of sentence. The state has sufficiently alleged violations of the special conditions of probation. Appellant alleges. So now this is only allegations in a pleading. It's not factual admissions. Now it's just allegations. We're back to pleadings not being, testimony under oath. Appellant alleges that the state's revocation petition does not allege any violations of his special conditions of probation. This stems from appellant's overly technical reading of his sentence sheet. First, as stated above, the special conditions of probation were listed in the sentence sheet. The revocation petition refers to special conditions A through D. The footnote says, when listed in the revocation petition, it appears that these conditions are copy-pasted from the sentencing agreement. The sentence sheet incorporates the sentencing agreement conditions, but changes defendant to you. It specifically stated that in his violation, that when appellant testified in September 2004, he directly contradicted the special conditions of his plea agreement by disavowing the factual acknowledgments he had sworn were accurate and true during the plea hearing on December 28th, 2022. Now, if I'm not mistaken, the signature we have is on the old version of the agreement, the exhibit AS1. So, this is a direct violation of special condition B, as the petition alleges that he violated a special condition as listed in the sentence sheet. The petition sufficiently alleges violation of his special conditions. C, the trial court found violations of the special conditions of probation. The trial court's revocation referred to the special conditions of probation that were listed in the petition. As stated above, the petition referred to special conditions of probation. While the order generally referred to the petition can provide the basis for the revocation of probation. And then let's see. Haji v. State, using the probation revocation hearing transcript to inform the basis for the revocation. Further, the trial court stated its reasoning for the revocation during the hearing. Thus, I don't really remember what Abadi argued on the record. I remember more of Derek Wright talking, and then Whitaker just going. And even when it came down to, discretion, Abadi was like, we'll let the court decide on what to revoke. We're not even going to recommend a recommended revocation. Further, the trial court stated its reasoning for the revocation during the hearing. And the reasoning was, I find it akin to perjury. Which, perjury is a charge, is something that a prosecutor would prosecute. There is no charge of prosecution charge of perjury against Mounk Tounk. So if the revocation is based on something being akin to perjury, I think that's problematic because it's an uncharged offense. The judge is essentially finding an uncharged offense as the basis for revoking probation in another case. I don't think she stated it as, we found that he violated this specific special condition. But further, the trial court stated its reasoning for the revocation. Thus, the trial court had properly found violations, plural, of petitioner special conditions of probation. So, 7, appellant's claim, and so I think there's an issue, Derek Wright sat down, he didn't stand up and really try to do much of anything, but how do you, someone says it's akin to perjury, but that's not what's in the petition, and then the attorney doesn't stand up. Should we just assume that it was revoked because the state said he violated a special condition under the special terms of sentence in the disposition? Because how do you argue against that in the moment if you're not even being put on notice to the specific violation? So, and yeah, YP says because he told the truth that is perjury. I would argue that one could argue that if he, falsely agreed in a plea agreement, but then tried to tell the truth or something more truthful on the stand, if he didn't do what he did on the stand, he'd be at risk of perjury charges. And we heard Hilton tell Woody, we can't use what you testified to as a lead to prosecute you for a charge relating to what you're going to say, but we could get you for perjury if you lie. So, one of those catch-22 boxes. Argument 7 is appellant's claims about his probation revocation are untimely. Even if it can be raised on appeal, the trial court properly took judicial notice of appellant's testimony. Appellant alleges that the trial court improperly took judicial notice of the proceedings at trial when it considered his probation revocation. This claim cannot be brought in this appeal. Even if it could be brought, the same judge who presided at the trial, for some of it, and not for the plea, and his probation revocation, could take judicial notice of the proceedings before her and properly gave appellant an opportunity to object. And remember, she was played, Whitaker was in court, and I don't think this would make it acceptable, but Whitaker was played a clip of the plea colloquy. But that plea colloquy was missing an important phrase. Additionally, at the probation revocation hearing, appellant induced this claimed error about judicial notice. First, as stated in the above section, appellant's claims about the probation revocation cannot be raised in this appeal. He did not avail himself of the discretionary appeal procedure in OCGA 5-6-35 and cannot raise these unrelated claims here. Even if these claims could be brought in this appeal, this claim fails. They're citing here that 24-2-201 governs judicial notice of adjudicated facts. The court may take judicial notice regardless of if a party requests it or not. What I think is interesting, if we're talking about adjudicated facts, right? Judge making a decision. But I would argue that the jury, the actual fact finder for the outcome of the trial, right? Not for the revocation decision, but at trial, the jury believed Mounk Tounk's testimony on the stand. I think it would be inconsistent, at least for the counts relating to Donovan Thomas and this time period from 2000, the early 2000s, not the 2022 stuff, the 2010s. They found his testimony truthful. If they didn't, I think we would have seen convictions in relation to the Donovan Thomas counts. So, I don't know. Seems like the judge would disagree with the jury by finding that the testimony delivered in September of last year was akin to perjury. Further, a party shall be entitled, and again, that would mean if that's the case, then the dishonesty would be in accepting the terms of the plea agreement and the factual acknowledgments. Further, a party shall be entitled upon timely release request to an opportunity to be heard as to the propriety of taking judicial notice and the tenor of the matter noticed. In the absence of prior notification, such request may be made after judicial notice has been taken. I mean, Jim and Tiffany weren't present for this part. This was last year before they were counsel. Additionally, a court may take judicial notice of its own records and proceedings before that court. Under the old evidence code, taking judicial notice of a prior proceedings in juvenile court. We've also got taking judicial notice of testimony and prior proceedings in litigation between the same parties. I mean, is it really the same parties? She wasn't there for the plea colloquy. So I don't know. First, even after the trial court announced it was taking judicial notice, appellant asked the trial court to take judicial notice of his testimony. So that's what they were talking about above. Just his own, just Mounk Tounk's testimony or Derek Wright's testimony and the proceedings that occurred during the trial. He cannot complain of the error that he created by his own conduct. Well, and sometimes I hate that like appellant and the attorneys for the appellant, just formally, you'll always write the defendant, the appellant, Sledge. But here, I think this would be where it's worth it to state counsel for appellant, trial counsel for appellant, ask the trial court to take judicial notice of appellant's testimony or his own testimony, because this isn't very clear. So he cannot complain of the error that he created by his own conduct. Even if appellant could claim this as error, appellant's contention still fails. Appellant points to law decided under the prior evidence code. Both cases cited by appellant, Mann v. State and Graves v. State, were decided before the current evidence code. The new code amended the judicial notice provision to allow for the opportunity to be heard on objecting to judicial notice to occur after judicial notice has been taken. Okay, so when did this... I mean, this I gotta take at face value. Did they say when the new code came out? Yeah, so they don't say, but the new code amended the judicial notice provision to allow for the opportunity to be heard on rejecting to judicial notice to occur after judicial notice has been taken. No such request was made by appellant during the probation revocation. And again, that was a different attorney. And as stated above, he requested the trial court take judicial notice of the testimony. Of who? Specific. Be specific. Also, he does not complain that any of the underlying notice facts were wrong. Appellant had an opportunity to object, but did not, and even requested the trial court take judicial notice. I mean, if they argued that the underlying facts of the... What? First of all, in this appeal brief, so if what the state is referring to here is that in the appellant's brief, the appellant did not complain that any of the underlying noticed facts at the probation revocation hearing were wrong, that's just false. Because we're glossing over, at the very least, the entire issue with the mention of sexual battery being part of Antonio Sledge's criminal history. That was a big complaint, and explicitly stated as factually incorrect. So if that's what they're referring to here, this is just not applicable. Appellant had an opportunity to object, but did not, and even requested the trial court taking judicial notice. So again, I think this could go to Derek Wright. Finally, the trial court properly took judicial notice of the proceedings that occurred before it. The same judge sat during appellant's trial testimony and his probation revocation, but not the plea. Contrary to appellant's contentions, the judge did not transform into a witness because she presided over his testimony. She would ascertain the same adjudicated facts whether she observed appellant's testimony or read them from a transcript. None of the facts that she observed, well, if she read it from a transcript and the entire Alford plea was stricken from the record, a transcript wouldn't have that. And there's a reason. There is a reason that appeals courts look at judges as a sort of 13th juror, because appeals courts would get a transcript that would be naked and barren when it comes to things that were stricken from the record. They're barren from other pieces of context that don't make it into the record that goes to the appeal court in the volume. This is a dumb argument. It could be argued that, if the hearing went differently, Whitaker still could have come to the same conclusion. But to argue that she would ascertain the same adjudicated facts if she only had a transcript and wasn't the trial court judge? How do you say that? How do you say that when we have an entire Alford plea stricken from the record? None of the facts that she observed came from an extrajudicial source. Holding to warrant recusal, the personal knowledge must come from an extrajudicial source and not from the judge's participation in the case. I mean, that's interesting, but it doesn't seem like to warrant recusal. This issue isn't requesting a recusal, it's requesting proper judicial notice being taken. What are you taking judicial notice of specifically, and not just, I saw it, whatever. So I don't know. I feel like this is sort of related enough because it deals with judicial notice, but it's not really related in the request being sought. Thus, this contention must fail. Therefore, created by EGF says we need to put this on Goodreads to give me at least as much credit as listening to an audiobook. Heck yeah, this is a lot of reading, a lot of vocabulary. I think it should count. You could rate it too. You could give reviews. Ella says, I'm gonna watch this tomorrow. Heck yeah. Good to see you. Hope you've been doing well. Yeah, this was a bit unplanned. This one was a bit unplanned. But we're all here to see what's going on with the Mounk Tounk appeal. Catch up on it. Don't forget, Friday also, Jim will be doing a stream. I'm sure he'll talk about some other stuff, but mostly this. 8. Okay, so the ineffective assistance of counsel claim as to his guilty plea is not properly before this court. Interesting. So, an ineffective assistance of counsel claim is kind of an inherent issue, I think, to this argument 7 and argument 6, maybe some others. But they're arguing, well, counsel didn't object, and now they're like, well, you can't consider whether or not counsel was effective here. The ineffective assistance of counsel claim as to his guilty plea is not properly before this court. So maybe that can't be an enumeration of error that the Court of Appeals can rule on, but as far as the consideration, the contextual consideration of the other issues being raised, context matters. Appellant alleges he received ineffective assistance of counsel during plea negotiations and sentence. And revocation? Okay, they're going to do that separately in 9. Okay, so first they're just dealing with ineffective assistance of counsel in plea negotiations and sentence. The ineffective assistance claims were not raised in the trial court, and appellant has pointed to no ruling on the claims. This court is a court of review for the correction of errors made by the trial court. This issue is not properly before this court and should not be considered. Again, I think the context is important because we're arguing, did somebody knowingly and voluntarily agree to this plea and the sentence that came with it? The presumption, we see the state cite case law here that there's a presumption that counsel informs. Thus, it's a knowing decision if they're represented at a hearing and they agree to a plea. So I think the context is necessary to consider. But maybe they won't say, hey, we're going to issue this decision based on this particular enumeration of error. So, 9, the effective assistance of counsel claim concerning his probation revocation is not properly before this court. So now we're dealing with Derek Wright at the October 2024 revocation. Appellant alleges he received ineffective assistance of counsel during his revocation proceedings. This issue is not properly before this court. The ineffective assistance claims were not raised in the trial court, and appellant has pointed to no ruling on the claims. This court is a court of review for the correction of errors made by the trial court. Additionally, as stated above, claims relating to his probation revocation cannot be raised in this appeal because appellant failed to timely petition for a discretionary appeal of his probation revocation. Well, that I would argue is because we've got different counsel. And I really hate, there are timetables that will block, post-conviction relief vehicles. Even if someone's unrepresented, time barring can get in the way. And it's an issue that I think is really problematic because if somebody has a valid issue, a meritorious issue to raise, and we're going to time bar them because they didn't have the know-how, the wherewithal to know how to just become a lawyer and know what they're supposed to file when and by when, I don't think that that's in the interest of justice. So, but here, again, we know in this circumstance, we didn't have Jim and Tiffany back in October of 2024. So it's not like they were going to be there to walk out of court that day and said, we're going to petition for a discretionary appeal. So, and then conclusion, wherefore that the state respectfully requests that this court affirm the judgments of conviction. And they have to say, you usually have to verify that you're not going past the word count. I think Jim mentioned earlier in the chat, I'm not going to scroll back up for the specifics, but it was like 15 words shy of the word count limit. Something like that. So, and then we've got Alex Burnick, who, again, I think he was thrown into doing this appeal. Jim gave us the context that he's the same one that wrote about the forfeiture, the Young Thug forfeiture issue. The state's reply on that matter the night before this was submitted, so it kind of makes some sense. So guys, let's rate this a 1 out of 10, a 1 to 10 scale. What do you guys think? What do you guys think? Do you have a stronger argument, a not so strong argument? I mean, they kind of conceded that, the deprivation of the right to be present at a critical stage, you're getting resentenced on something. State's just kind of like, yeah, Whitaker was wrong for that. So, I mean, is that alone enough? And there's some issues that I would say typically, maybe I would imagine a court of appeals not wanting to address. But if the court of appeals reads through this, there's just some weird arguments that would make me look at an issue that otherwise might not need consideration if we were going to already decide one way or another. But I mean, this idea that the word can't be done this way is a mere suggestion, not a rejection. Obviously, the court wasn't able to accept it the way it was. Therefore, it rejected it. The idea of this package deal, I think they might want to talk about that. I'd want to talk about this issue. I think there's a lot of case law on this, and I'd want to have my 2 cents in there. And yeah, so my thing with this, so we saw that they hammered down, they're doing an overly technical reading of the final disposition. What does it matter? But I would argue by making that argument, they're entirely watering down their argument, and they make 2 arguments about this understanding, the supposed understanding in 2022 about 131 versus 133. And if they're going to argue an overly technical reading shouldn't warrant a change of something, well then necessarily, how are we going to warrant someone saying yes ma'am orally in court? How are we going to argue that that's substantively they agreed to what matters? That's the count. The count determines the sentencing structure. Sentencing structure we now know the trial court later found to be void as a matter of law. I don't know. It just doesn't make sense for them to harp on that being a technical reading. And I don't know, did they respond? Was that kind of like in order of response? I feel like they put that further down because they were like mad about that issue being argued. And they didn't want to lead out the gate focusing on that issue. Shout out to Corky Marie, who's going to be on Rewatch Crew. Jersey Girl Trakeisha just says Glee. With the I did these crimes. We've got a -3 and a rating of 3. And a 3 because it kept to the word count. Lots of 3s, you guys. So, and if you do, I really will try. I mean, I've been wanting to go see my brother anyway. I've been trying to take some time in the past couple weeks to, like, we've been trying to, like, play a game together at night. So that's been really nice. And we're both kind of nerds, so, like, us jumping in a voice chat, for the sake of me and my brother, that's pretty much like being together in person. But for other family members, right, like my mom, I don't get that same experience. My mom is not going to jump on a voice chat and play a game with me. So I do want to, like, take a trip to Georgia to see some family, and I would use that as an excuse. I'd be like, I gotta go see this at a live hearing. So if you do that, please let me know. Let's see. Oh, it's, sorry. Yeah, over on this side, I only see the words for the emojis, and I forget what they mean. But it was Paige saying, if I did, I did. Let's see. Vague and ambiguous, good to see you, says, sometimes it may have felt like reading a third grader's essay, but just a lot, you guys. Thanks for dealing with me, like, screaming and raging. I'm gonna wake up tomorrow losing my voice, and I'm gonna be like, am I sick or was it from screaming at the screen? We'll have to decide. Yeah, the important question, Kent Clark says, will Antonio be present once this hearing goes down? So there you go. Recall to an issue with the resentencing after the vacating of sentence. Also, you guys, we mentioned it a bit at the beginning, but if you joined late, let's say this goes nowhere. The next move, I believe, is, and I think you could take more than one gym, but I believe the route that Whitaker pointed you to was go here first. If this fails, then bring this motion for reconsideration of the vacated sentence back to this trial court level. So that would be the next thing. It'd be more filings. It'd be more arguments. I suppose we would see for sure. Well, they shouldn't be raising this issue here. Well, we'll go see that in that avenue if we have to take it there. So, yeah, Leonard Amber, it's impossible to save my voice. I knew I'd be screaming. Brooklyn had asked in this morning's chat, the Courtney Clenny chat, like, can you rate the state's reply? And I'm like, well, I haven't read it yet, but I bet I'm gonna scream at the screen. So, heck yeah. So, Trakeisha, same thing. You'd go and then head to Savannah to see my mom. That would be fun. We could definitely get some lunch, get some food. Doesn't need to be lunch. Shout out to Keith from Chicago. Thank you for hanging out with us. Aaron says 1 star because at least they submitted something, which is more than I can say for the Georgia Attorney General's office. Just, oh man. I think I set this up to redirect over. Factual Lie had let us know about the Kelsey Fitzsimmons. Her appeal was denied. Justice Serve TV is talking about that tonight starting at 6, so we're right almost on time. That's where this is going to redirect us to, so I didn't get to catch that because we've been streaming all day. I'm going to go hang out over there. It'll be a good time. Jim, can we read your guys' reply one of these days? Because if we can do that, we'll get together for that. And between now and Friday, you guys, we've got one day. Make sure you clear your calendar for, I don't know, maybe like 5 p.m., 6 p.m. seems to be Jim's sweet spot for going live. He's going to be streaming, and he's been MIA from us for like 2 weeks. We've got to go in his chat and watch him rant and bant. So mark your calendar for Friday evening Eastern time. If you aren't already subscribed, let me drop his link. We've got to make sure he holds on. I'm sure he's ready to talk about this a little bit. But in case he's not, we've got to put the pressure on. So make sure you subscribe. Link is in the description and also dropping in the chat right now to Jim's channel. Hit the subscribe button and then click it again. You might have to press and hold on mobile. And then make sure you're getting all notifications with that little bell icon. Because even if you don't know when he plans to go live, YouTube will usually tell you that someone's going live if you hit that bell for all notifications. So, yeah, it's been longer than 2 weeks. I'll take you at your word. I believe that. We have been missing Jim. Dietrich says, I have been trying to get a reason to go to Atlanta. Well, here we go. Here we go. we have a chat meetup, and it's in the courtroom to watch Jim and Tiffany at an oral argument at the Court of Appeals. That would just be really cool. That would be super cool. As long as they don't think it would put pressure on them, right? I don't want to be in there and make them nervous, but I think they'll do just fine. So, with that being said, you guys, we're going to get over to Justice Served TV. If you're interested, again, pop in and show them some love. I love what they do over there. They cover a ton of stuff. They have Doug on periodically as a guest, so it's a great way to see what Doug is up to and what his thoughts on other cases are. And today specifically, again, they'll be talking about Kelsey Fitzsimmons' appeal. JSTV link in the chat in case you need to use a link to get over there. Otherwise, this should redirect you. And big thank you also, again, to, that. Always good to see you when we do these YSL streams. I love pulling up the Bruce Harvey picture on the screen. This theme makes it, like, bigger, I think, than my other theme. Like, the other one's usually, like, a little square. So maybe whenever you show up, we'll have to use the circle theme so we can see Bruce live in living color. Fallon, thank you so much. Jersey Girl Trikesha, thank you so much. And 14 months is incredible again. So thank you for supporting this channel for 14 months. It's a lot. And then Laundered Amber with the 6 months. I think it's been longer than that. Heart hands, heck yeah. Heck yeah. That's an easy way. That's my way of showing love without having to pop the microphone on during a stream. So looking forward to this Friday. Looking forward to maybe reacting to Jim and Tiffany's reply, if we can take a look at that. Because there's things that I need answers on, right? I'm reading some of this and I'm confused, so I want to make sure I'm not crazy and see what they have to say in response. And then if we don't see you at Justice Served TV or Friday, see you next time, you guys. Thank you so much.